Mr. Tobin?
Yes, Your Honor.
How are you doing, sir?
Very well, thank you, Your Honor.
Thank you. Thank you, Mr. Tobin. If you could just come to the center. Okay.
May I approach?
Sure.
Thank you, Your Honor.
Thank you, sir. Give it to the other side. All right.
Good to see you.
Mr. Tobin, if you want to.
Certainly, Your Honor. Thank you.
I got to make this relatively short, as you can understand, but I wanted to take up your motion. I have read your motion and the declaration and everything attached to it in all the cases, and I have reviewed it, so I'd rather you not regurgitate that based on our time limit, but anything you wish to add to that is fine. If you want to, if I could focus you a little
Please.
bit. Okay.
Thank you, Your Honor.
All right. And yes, sir. As far as your comments about Virginia Rule of Evidence 2:508, that's a criminal rule of evidence. So that's not your strongest argument. And as far as what goes on is when or if the witness testifies, whether it's hearsay or it's third-party knowledge, that's something I'll deal with at trial. So again, not what I'm concerned with. As far as Supreme Court Rule 314, which I would like you to talk a little bit about that as far as intervention. And I got to tell you where I'm at right now. The concern, the issue I have with the argument is intervention obviously would make you a plaintiff or defendant in the case, and it has to deal with an issue that's germane to this case, and this is a defamation case. So if you could just tailor your argument to that issue, sir.
Sure. I'm happy to address the intervention. For the record, Your Honor, Charles Tobin from the law firm of Ballard Spahr.
Yes,
here
sir, Mr.
representing TMZ, which is the publisher of news and entertainment for the celebrity and entertainment industry. And Your Honor, we're seeking to intervene simply to protect the relationship between reporters and their sources when it comes to reporting news in the public interest. As the court noted, we really don't have a dog in this hunt as far as Mr. Depp misheard. We're really here purely on the First Amendment-based issue of reporters' privilege and reporters and their sources. Your Honor, the intervention rule, as the court is aware, allows intervention by anybody where the issue is germane to the subject matter of the proceeding. And certainly, Your Honor, the purported testimony, the proffered testimony of a former employee of TMZ who purports to be in a position to disclose confidential information learned during the operation of journalism, during his work as a journalist, is a germane issue that is being raised in this case. And Your Honor, we would point the court to the Tafts, Fletcher, Malden, and Reed versus Southern Bank and Trust case, 213 Virginia Circuit, Lexus, 253. It's a Norfolk Circuit Court decision from 2013. And there it was an interpleader action. The funds had been interpleaded into the court by two trust companies that were fighting over it. And the man who had sold his property, who had no interest in the funds themselves, intervened in the case because he was uncertain as to his liability for excess funds, which was an issue that was not directly in litigation between the two parties. It was not part of the cause of action between the two trusts fighting over the money that had been pleaded into the court. The circuit court held that certainly the rights of that man was going to be affected by the decision making in the case. He would be prejudiced if he didn't have an opportunity to intervene, and no party was in a position to assert his rights. And so similarly here, Your Honor, TMZ is a news organization. It routinely accepts information, as is common in journalism, under exchanges of promises of confidentiality. If it is not able to intervene in this action, and neither of the parties is going to be in a position to assert the reporter's privilege, it is TMZ's journalist privilege that we're talking about, then the rights are certainly going to be prejudiced.
But if the witness, in all the cases, and I reviewed the cases that you had, in those cases the witness was compelled to testify and came and was forced to testify, so there was an issue about the privilege of the witness. It's my understanding in this case this witness wants to testify and is not under subpoena.
He has been subpoenaed, Your Honor.
That's incorrect, Your Honor. He's voluntarily. A subpoena from this court would not be enforceable.
Okay.
Your Honor, I have a copy of a subpoena that was entered last night compelling Mr. Tremaine to give testimony in this case. And so he is coming under a compulsion under
Well,
subpoena.
and if he takes a stand and he asserts some sort of privilege, then that's something I will deal with at that time.
Sure, but I'm here because of the scenario where he may not assert that privilege.
Right, exactly, and that's that's why I'm saying all your cases that you showed were the opposite, where they did assert the privilege.
Well, it is a unique situation.
Right,
where-
and I understand you might have some issues with a former employee, and you have some avenues to go deal with that.
But once he testifies and the privilege is waived, we have lost our opportunity to intervene and to intercede.
All right.
And, Your Honor, the privilege, I know, Your Honor, you said you read the case law.
I did.
Appreciate that.
Yes, sir.
But the privilege has been recognized by the Virginia Supreme Court in the Brown case and applied by the circuit courts uniformly. It is a very important underpinning of the relationship between reporters and sources and reporters and the public. Without the ability to enforce its promises by current employees or former employees, a news organization will have absolutely no control over being able to enforce its promises. And so we would ask the court to permit us to intervene and to assert the privilege that belongs to TMZ, which is the organization, after all, Your Honor, that would be responsible to the source if the privilege were waived.
All right, I understand, Mr. Tobin, your argument. I appreciate it very much. Okay, did the parties wish to be heard?
Good morning, good afternoon, Your Honor. I'd like to begin where Your Honor began. As a threshold matter, the court should deny TMZ's motion to intervene. Intervention is not appropriate for the reasons suggested in Your Honor's questions. As Your Honor is well aware, intervention is only appropriate with leave of court where a third party seeks to, quote, file a pleading to intervene as a plaintiff or as a defendant to assert any claim or defense germane to the subject matter of the proceeding, unquote. Virginia Supreme Court Rule 3:14. As Mr. Tobin, to his credit, has conceded, TMZ is not asking to file a pleading. It cannot properly categorize itself either as plaintiff nor defendant, and it seeks to assert no claim or defense germane to the subject matter of this action. Moreover, even if the privilege were applicable, which is not the case here, the testimony intended is directly relevant and would outweigh any qualified privilege. Quote, an intervener must be asserting an interest that is part of the subject matter of the litigation, unquote, Hudson versus Jarrett, 269 Virginia 24/32. Here, as Mr. Tobin stated, TMZ seeks to protect potential information solicited from a third-party witness, which is in no way a matter before this court, citing Commonwealth versus Gill, 89 Virginia Circuit 323, a 2014 case denying a motion to intervene where the intervener filed it, quote, to protect a property right, not a matter before the court, unquote. The outcome of this trial will not affect TMZ, and it does not have a sufficient interest in the subject matter of this suit to intervene. See Texas Fletcher, Maiden and Reed, PC versus Bank National Trust Co., 2013 Westlaw 5849140, granting, and this is distinguishing it, granting the motion to intervene where the intervener's liability would be affected by the outcome of the litigation. Finally, Your Honor, TMZ lacks standing to object to testimony by a third party in this action because TMZ, as Your Honor pointed out, is not being compelled to testify. TMZ's reliance on the Philip Morris case for the proposition that the privilege cannot be circumvented by seeking confidential source information from an employee is inapposite. 36 VA Circuit at 1. For one thing, as noted in that case, there is no testimonial privilege akin to that enjoyed under the Fifth Amendment, which would allow a reporter to refuse to appear before a grand jury and answer questions. And Philip Morris, as Your Honor is aware, the party issued a third-party subpoena for records to trace confidential sources. Philip Morris is inapposite here, as that case related, as this case is related to witness testimony, not records. As Your Honor suggested, TMZ's quarrel, if any, is with Mr. Tremaine to the extent that he had an NDA that was enforceable, applicable, and that's not what we're hearing from Mr. Tobin. So to the extent that TMZ, which is not exactly Edward R. Murrow, Your Honor, to the extent they have a beef, as it were, a cognizable beef, it is with Mr. Tremaine. It is not with Mr. Depp, and they clearly do not have standing to assert or to intervene because they are not intervening as a party, plaintiff, or defendant. So we respectfully submit, to the extent the court disagrees, I can go into the arguments why the privilege is inapplicable, but I will reserve that.
Thank you. All right. Yes, ma'am.
Your Honor, I would like to weigh in from just a different perspective,
Okay.
and that is because we're trying to deal with some important issues of privilege, et cetera. But from our perspective, representing Ms. Hurd, we have issues with this witness separately, and I want to make them very clear for the record. This is somebody who should have been identified in discovery, was never. Second of all, it's not relevant whether, apparently what they're saying he's going to testify, and we have not had the opportunity to discover that, is he's going to claim that someone leaked to TMZ that Ms. Hurd was going to obtain the TRO on that Friday and also leak the video, the kitchen video with Mr. Depp being rather violent. I'm almost certain he's not going to claim it's Ms. Hurd, so I think it's never going to come in.
All right. Ms. Bredehoft, I understand all that argument. Do you have any argument as to this particular motion?
No, my
Okay, well, then we can address you.
My point is, though, if you balance the prejudice versus the probative value, I don't even see how he can come in on foundation or hearsay or relevance.
That's just not part of this motion at this time. Thank you, ma'am. All right, Mr. Tobin, your motion, you get the last word, sir.
Thank you, Your Honor. You know, I appreciate that the court shook your head when he made the snarky comment that this is not Edward R. Murrow. Obviously, the First Amendment applies to everybody, citizens, the New York Times, or TMZ. And this is a First Amendment-based privilege. Your Honor, the Philip Morris case is actually a very good case to answer Your Honor's question about the intervention of somebody else in order to assert the privilege. There, ABC was a defendant in the case, and it moved in order to prevent other people, the phone company.
Right. But they were already
airlines.
in the case in that particular
I understand.
matter.
There is no other mechanism, though, and so it would be an interesting procedural issue for appeal, Your Honor, whether a journalism organization or anybody else who's a First Amendment holder would be denied intervention on a constitutional-based privilege. I also, just for the record and for the merits of the case, if I understood Mr. Chu correctly, he said this is not an issue in the litigation. This does not relate to an issue in the litigation. Well, if it's not an issue in the litigation, if it's not part of a prima facie part of the defense, part of the allegations of the complaint, if it's impeachment evidence, if it's collateral to the main issues in the case, under the Brown v. Commonwealth decision under the Virginia Supreme Court, under the application of that privilege in the Philip Morris versus ABC News, it is not supposed to be compelled in this case.
Which is, again, it's not being compelled, it appears.
Well, he is appearing by subpoena, and it is a compulsory process, and he will have an obligation unless he asserts privilege under oath. But it is our privilege, Your Honor. It's not an employee, a loyal or a rogue employee's privilege to waive on behalf of its employer. This is an unusual situation.
Tell me about it.
But the answers are there in the law, and it is a First Amendment concern.
This is not the first unusual situation in this case. I can
For either
tell you
of us,
for Mr. Tobin.
for anybody here, I'm sure.
Yes, sir. I appreciate you coming in today, and I appreciate
Your
your
Honor.
arguments. Yes, sir. Thank you. All right. In this matter, under Virginia Rule Supreme Court 3:14, a new party may intervene as a plaintiff or defendant to assert any claim or defense germane to the subject matter of the proceeding. A new party may not intervene unless they assert some right involved in the underlying litigation. A party is not entitled to intervene merely because a byproduct of the litigation adversely impacts them, and the decision to allow intervention is within the broad discretion of the trial court. Here, the rights asserted are not germane to the trial. The central issues in this case are whether defendant defamed plaintiff and whether plaintiff defamed defendant through a theory of vicarious liability. The issue of the confidentiality of sources has not come up as in other cases cited by EHM, which is the corporation that TMZ belongs to, is under their umbrella. In Brown versus the Commonwealth, there was an attempt by the criminal defendant to subpoena institutions in order to obtain the name of the confidential source. When the author of the article was subpoenaed, she refused to identify her confidential source on the stand. And in this case, it appears that the witness is willing to state the name of the confidential source without being compelled voluntarily. Whether that breaches a non-disclosure agreement between Mr. Tremaine and EHM is not germane to this matter and can be litigated in a separate matter if EHM so chooses. And while breaches of contract must be taken seriously, and the court does, any alleged breach is not germane to the underlying litigation here. That contractual action has no bearing on this case and is thus not germane to this litigation. Therefore, I'll deny the non-party EHM Productions motion to intervene.
Thank you, Your Honor. For the record, I've known Mr. Tobin for several years. I meant no snarkiness toward him.
Well, you're just a snarky guy.
Issue for the record.
Ashley, Mr.
Your Honor, I am concerned that we preserve the issue fully, and so
For the record, yes,
for the
sir.
record. And so I would ask, may I have the opportunity to object when Mr. Tremaine is questioned by question?
No, sir, you're not a party to this case. However, I will note for your record your objection to his complete testimony on behalf of your client.
Right. Thank you, Your Honor.
Okay, thank you. Your microphone, Ms. Brewer.
As with the Hicksville witness, Your Honor, I would ask that we could voir dire him before the jury to find out when he contacted counsel and when they became aware of it. And I think also, under the circumstances, in fairness, I think we should at least be able to ask him what he's going to claim.
Response.
Your Honor, I don't think that's appropriate. Certainly, I don't think a proffer is necessary or appropriate in this case.
I'm not going to do a proffer in this matter, okay? All right. Oh, Mr. Rottenberg, I
Sorry.
was almost at lunch.
I know, I'm so sorry. But I truly am the messenger here, because Mr. Murphy just informed me that he has to just clarify one thing
Give me
about.
just one clarification.
Okay,
on
all right,
Elaine.
okay.
I apologize.
That's fine. I think we need Ms. Myers.